Next case that the court will hear is State of Ohio versus William Weaver. It's case number 17CA0092. Are both parties ready?
We are, Your Honor.
Very good. Each side will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. And please keep your voice up as these are recorded. The court has read the briefs and are ready when you are to proceed.
Thank you, Your Honor. If I could reserve 3 minutes for rebuttal.
Very good, thank you.
And thank you. I'm Pat Brown. I represent the appellant, William Weaver, in this case. Your Honors, in this case presents two distinct issues that we've raised. The first one, was there clear and convincing evidence that Mr. Weaver committed the charged offenses of kidnapping? And that raises the related issue of whether, and this court will have a chance, I believe, to be the first appellate court in the state to address this, do the rules of evidence apply to these kind of proceedings under 2945.3982? The second issue is, was there clear and convincing evidence that Mr. Weaver was either mentally ill, subject to court order, or intellectually disabled and subject to institutionalization? I'll start with the first issue. Was there clear and convincing evidence? Before the court can address that issue, it has to decide, do the rules of evidence apply to these kind of proceedings? And we cited State v. Jones from the Ohio Supreme Court, which held that evidence rule 703 applies to a proceeding similar to this one, where the issue is whether the court should retain jurisdiction over a person found not guilty by reason of insanity, which is the same legal standard applied to these cases where Mr. Weaver was found incompetent. So if we apply the Jones rationale, the rules of evidence should apply to these kind of proceedings, and that makes sense. These are very serious proceedings. They're essentially to determine, one, did someone commit a crime, and two, should they be institutionalized? And the consequences are severe for Mr. Weaver in particular. He faces up to 8 years of being institutionalized. So it makes sense that the rules of evidence would apply to these kind of proceedings, and if the court follows the Jones rationale, they should. If the rules of evidence apply, then the testimony of Emily Justice in this case, which relied on hearsay testimony of the minor child, should have been excluded. Now, the state has attempted to justify that testimony under the medical diagnosis exception, but if the court goes back and looks at the transcript of Ms. Justice's testimony, no foundation whatsoever was laid for the medical diagnosis exception. There was no testimony about whether the interview was for purposes of treatment or diagnosis. None of that is in there. In fact, this interview took place in a police station in the presence of a detective, and it looks for all the world like they are trying to gather evidence to prosecute a criminal case. That's what this was. So if Ms. Justice's hearsay testimony of the minor child is excluded, what we're left with is the admission or the statement of Mr. Weaver that he gave to Detective Grusendorf in this case. Our position is that there's no way that can be clear and convincing evidence that Mr. Weaver committed the offense of kidnapping. In this case, essentially what Mr. Weaver admitted to was hugging and kissing. It's undisputed that he's intellectually disabled. There was no testimony about whether he had sexual intent, which is an element of the crime. There's no testimony about whether he's even capable of forming that kind of intent.
Wasn't the trial court permitted to infer sexual intent?
I suppose the trial court would be permitted to infer that, but I'm not sure what they're inferring that from.
How about a tongue in a mouth?
Well,
I hate to be graphic here, but that's what the testimony was.
That is what happened, and I suppose the trial court could infer that, Your Honor. Mr. Weaver's statements to Detective Grusendorf weren't explicitly sexual. I guess the trial court could infer that. Remember, this is a clear and convincing standard, though it's the highest burden we have in a civil case. But that brings me to my second point. Even if the trial court found clear and convincing evidence that Mr. Weaver had committed the offense of kidnapping, there's certainly, in our view, no clear and convincing evidence that Mr. Weaver was either mentally ill and subject to court order or intellectually disabled and subject to institutionalization. And, those are two separate issues. With respect to the mentally ill part of it, 3 experts looked at Mr. Weaver. Not one of them found that he had a mental illness. 2 of them affirmatively testified that he did not have a mental illness, Dr. Seibel, Dr. Cowan. And Dr. Seibel was called by the state as a witness. Dr. Seibel said he doesn't have a mental illness. illness. I'm not qualified to determine whether he should be subject to institutionalization, so this trial court appointed Dr. Cowan. Dr. Cowan evaluated Mr. Weaver, and Dr. Cowan found not only does he not have a mental illness, but he's not moderately intellectually disabled, which is what the trial court would have had to find to institutionalize him. Essentially, the trial court ignored the expert testimony in this case and focused on facts from an evaluation team report conducted 30 years ago when Mr. Weaver was 16 years old. And the trial court concluded, well, they said he had a 54 IQ back then, so he must have a 54 IQ now. Now, the most recent IQ test says his IQ is 57. Okay? But that's only one part of the analysis. The trial court was also required to find that Mr. Weaver has moderate deficits in adaptive functioning. There is absolutely nothing in the trial court's entry regarding that second part. Dr. Cowan testified, and this is clear from the record, Mr. Weaver was able to live independently. He was able to work. He was able to drive a car. He was able to hold a job. All of this with minimal oversight. There's no evidence in the record that Mr. Weaver had moderate deficits in adaptive functioning. In fact, Dr. Cowan said that he was significantly above where someone with a moderate disability would be. He was in the high, mild range of intellectual disability. If that's the case, then he's not subject to institutionalization. There's no evidence of a mental illness. There's no evidence that he's moderately intellectually disabled. So even if the trial court found that he committed the offense of kidnapping, there was no basis to institutionalize him. He should have been discharged. And especially on the thing about this case, it's a clear and convincing evidence standard again. And in our view, the trial court shouldn't have been permitted to just disregard the expert testimony without explaining why and focus on these facts from a team report from 30 years ago when it's not even clear from the record that the underlying methodologies that they reached in that report, it's not clear that that's reliable in any shape, way, or form.
Counsel, when we have a chance to look at the complete record beyond the briefs here, I recall reading in the briefs that there were allegations that Mr. Weaver was having, I think the word was inappropriate, I don't believe it was necessarily contact, but something with the actual workers where he was. What was the nature of that inappropriateness?
It's not clear from the record. Whatever it was extremely minor. It wasn't a big issue. I mean, Mr. Weaver, if we look at him, he has no record of violence, no record of sex offenses prior to this case. There was some passing reference, you're right, Your Honor, to some inappropriate contact. I think part of it had to do with his grooming. He had to be prompted to groom himself, but I don't see what that has to do with whether he should be subject to institutionalization.
Well, I guess what I'm getting at is, would there be a difference if the inappropriateness was grooming or, I don't even want to say grooming because mouthiness versus attempting to kiss or something of that nature? If it were the latter, arguably then the court could be relying on something a little more recent, although I don't know that the court put that in the opinion. But
it wasn't in the opinion, and I don't believe it's clear from the record that that's what the nature of that is, Your Honor.
Thank you.
Attorney Brown, do you think the court had the ability to, or do you think it was proper for the court to look at the totality of the circumstances, which I think is the test he applied here, in addition to the experts? I think the inappropriate conduct towards the staff for hygiene, there's some mention about him being angry with peers, I think. Or are you arguing that the court is limited to the expert testimony?
Well, the court's not limited to the expert testimony, but the court never gave a reason for why it was disregarding this expert testimony. I mean, these experts were credible, they were qualified. There was no dual, this wasn't a situation where there were two experts and the court said one was more credible than the other. The court simply disregarded the expert testimony. In fact, cherry-picked part of Dr. Seibel's testimony. Dr. Seibel, and the court relied on some of what he said in his judgment entry. Dr. Seibel said that Mr. Weaver has no mental illness. Dr. Cowan said the same thing. So certainly the court can look at the totality of the circumstances, but under clear and convincing evidence standard, I'm not sure how that, when you have the expert testimony saying, no, this man is not mentally ill, he's not moderately intellectually disabled, frankly, it's not really a close call. The court, if it's going to completely disregard that, should provide some kind of reason. That wasn't provided. The court focused on, the trial court focused on the fact that Mr. Weaver, well, he wanted his charges to go away. That's one of the things it focused on. Well, I think that's a pretty normal instinct to want your charges to go away. If that qualified as making someone mentally ill, then there'd be a lot of criminal defendants in Ohio who are mentally ill. I think a lot of people want their charges to go away. You know, there just wasn't enough, even looking at the totality of the circumstances, there certainly was not enough facts to overcome this expert testimony and find by clear and convincing evidence that he was either mentally ill or moderately intellectually disabled. The evidence just wasn't there. And that's why we're asking this court to reverse that judgment and to discharge Mr. Weaver.
Let's go back to the statement, the victim's statement at the police station. What was the involvement of the police officer during that interview? Were they taking notes? Was it being videotaped? What's there that would indicate it was more for purposes of use at trial as opposed to a medical diagnosis?
Well, I guess it looks like, why else would a police officer be there, Your Honor, other than to gather evidence for a criminal proceeding? But the state had the burden here, and there was no foundation laid. I guess the point is there was no foundation laid for the medical diagnosis exception. I mean, this was hearsay, and the state can try to get it in under one of the exceptions, and the state said, well, this meets the medical diagnosis exception. But Ms. Justice, there's absolutely nothing in the transcript where she says, I was interviewing her for purposes of diagnosing her, for referring her for services. There was no foundation laid for that exception, which the state would have to do. You can't just assume it's for medical purposes. There has to be a foundation laid, and I guess that was the problem. With respect to why the officer was there, I don't know that it's clear from the record, but it sure looks like he was there to gather evidence to prosecute Mr. Weaver. I don't know why else a police officer would be there. He was investigating a crime.
All right, you have 3 minutes and 17 seconds left for your rebuttal.
Thank you, Your Honor.
Morning, Your Honors. May it please the Court. I'm Vince Vellucci with the Medina County Prosecutor's Office for the Pele, the state of Ohio. I will begin with first assignment of error, which is actually two distinct arguments. First, do the rules of evidence apply to a hearing like this? And I agree with Mr. Brown. I don't believe that has been decided by an Ohio court yet, whether the rules of evidence apply to a hearing like this, and then the hearsay issue with the testimony of Emily Justice. First, in terms of the rules of evidence, the state of Ohio submits that the rules of evidence absolutely should not apply in a hearing like this. 101C of the evidence rules states that the rules of evidence do not apply to miscellaneous criminal proceedings, which include sentencings, bail hearings, things like that, among other things. It's a non-exclusive list also. At the time this kind of hearing is held on whether a court can retain jurisdiction over somebody, the defendant has already been found incompetent to stand trial and unrestorable. So there's not going to be a trial. No chance there's going to be a trial. The only question at that point that's left is what is the ultimate outcome going to be for the defendant moving forward, which sounds an awful lot like sentencing to me. Will he be just released without supervision, or will he have to stay in the mental institution where he currently is?
But in order to get to that, let's call it the sentencing component, doesn't he first have to be found guilty of the offense, although under this proceeding by clear and convincing evidence rather than beyond a reasonable doubt?
Correct, and that's another reason I think it's so unlike a trial. First of all, look at the burden of proof. You're talking about clear and convincing evidence, not like beyond a reasonable doubt like a criminal trial. This is actually a civil proceeding. This is not even a criminal proceeding at all.
Do the rules of evidence not apply to civil proceedings?
They do, but But I think in terms of, if you're trying to compare this to a criminal trial, it's nothing like a criminal trial. And I think if you look at Rule 102 of the Rules of Evidence, it talks about these rules setting out procedures for the adjudication of cases. Adjudication means trial, and this is not a trial. So I think it's much more like a bail hearing or a sentencing than a trial. Now, in terms of the rules of evidence, how they apply here, Ms. Justice's testimony was, even assuming the rules of evidence applied here, this was admitted as a statement for purposes of medical diagnosis or treatment, and I think that was proper because it's been held on several occasions by this court that a social worker's testimony is admissible under that rule. In fact, I think I cite 5 Ninth District cases in my brief alone, where, just from this district alone, where social worker testimony has been admitted as for purposes of medical diagnosis or treatment. Weaver, on the other hand, cites no Ninth District case. What he cites is one 8th District case, this Woods case, where a social worker's interview happened to take place in the presence of a police officer. At the same time, that the 8th District actually found that to be harmless error. So, and that's the other thing I would submit. Even if this was improperly admitted, it was certainly harmless error because there was overwhelming other evidence in this case, including Weaver's videotaped confession to the crime and his handwritten statement to the mother of the victim, saying, "I did this and I'm sorry. I'm sorry I kissed your 7-year-old daughter." Essentially, he admits the whole thing. This court has never itself held that the presence of a police officer is dispositive, that it automatically takes you out of the medical diagnosis or treatment. This court would be breaking entirely new ground by holding that, with no precedent whatsoever.
Of course, this happened at the police station.
It did, and there's some background to that. I think the context has to be understood as well as to why it took place at the police station. This was originally going to be scheduled with the mother of this child, I think normally like it would normally at the CAC or wherever they would do this. Unfortunately, the mother, they were having trouble contacting the mother, and I think she was being investigated for an unrelated issue by Job and Family Services. And that's why they weren't able to get her pinned down, basically, to be able to bring her to interview her daughter. And the only way to do that, it was really kind of to get the mother to comply, was why they had it at the police station, was to actually get her to show up with her child. In every other way, this was an interview with a social worker. It just happened to take place at a police station. The officer was not involved in this interview. Now, in terms of where he was in physical proximity where the interview was going on, I don't think that's found in the record. I don't know where he was. Is he behind glass? Is he in the room? Is he sitting right there? I'm not sure. But I think this was an interview with a social worker in every other way, and I think it's been found that it's diagnosis or treatment. So she doesn't have to be treating this child, and this has been held to be diagnosis, just to be able to assess what's going on with the child, essentially diagnose the child, connect the child with appropriate treatment or services that she might need. And that's been held time and time again by this court. In terms of the clear and convincing evidence as to whether he committed these crimes, this is 2 counts of kidnapping, felony 2 kidnapping with sexual motivation specifications. Emily Justice's testimony, as Judge Callahan mentioned, was very compelling. SW, this victim, was a 7-year-old girl. Her testimony outlines 3 incidents of Weaver restraining SW against her will and kissing her on the lips, but not just kissing her. In the first incident, SW says that Weaver came into her room and was helping her clean when he did this. SW says that Weaver hugged her with his chest and his privates pressed against her to the point that she couldn't lift her arms. She was certainly being restrained against her will. And Weaver didn't just give SW a peck. SW states that Weaver put his tongue inside her mouth and wiggled it around. In another incident, Weaver lifts SW up and kisses her 5 times, with some of them also being open-mouth kisses, where again, Weaver puts his tongue inside SW's mouth, a 7-year-old girl. Weaver tells SW that this was a secret and tells her not to tell her mother. Weaver later confesses to these crimes, like I said, in an interview with the Medina City Police.
To what extent? I guess the reason I ask is his, I'm going to call it the apology letter. He says he kissed her. He admits to having kissed her, probably on more than one occasions, but that put out the statement that's challenged here, pretend it's gone, go to your harmless error argument. Is that letter enough to get the elements that the state needs?
That letter without the recorded statement and without Emily Justice's.
What about his own statement? Does his own statement add anything that would get the elements that the state needs?
I think he talks about kissing her and hugging her, and I think the sexual intent can be inferred from that, as you mentioned. We've got an older man and a 7-year-old girl. You've got kissing that's, like I said, not just kissing, but so yes, I do think so. In terms of the weight of the evidence, Weaver puts on no evidence of his own, so there's actually none of his evidence to weigh against any of the state's evidence. His main claim on the weight of the evidence is that the videotape shouldn't be given much weight because he was found incompetent to stand trial. But that wrongly, I think, presumes that the trial court put a lot of weight on that. It's not found in the record or in the court's order how exactly they weighed different elements how the trial court weighed different elements of the state's case. In fact, in the journal entry, the trial court doesn't even mention the videotape confession. So I don't think it's clear that had more weight necessarily than other things. What is clear that court, the trial court, was in the best position to judge the credibility of all the witnesses and evaluate the evidence. And the trial court found by clear and convincing evidence that Weaver did commit these crimes. Again, a lower burden of proof than beyond a reasonable doubt. Now, on the mental illness aspect, again, we're looking at clear and convincing evidence as the standard. And Weaver's essentially saying that the trial court had to just rubber stamp what these 2 psychiatrists said in terms of being Weaver being mentally ill, just because they didn't scientifically, in a psychiatric sense, diagnose him as mentally ill, that the court had to find him mentally ill in the legal sense. And that's absolutely untrue. What the trial court's job was to do was to apply the definition found in the Ohio Revised Code, not what some psychiatrist technical definition of mental illness is. And I think it was also mentioned, courts have to consider the totality of the circumstances, not just what the psychiatrist says. Courts have to consider the facts of the case, which, as I think Judge Teodosio said, which in this case are very disturbing, as I laid out the facts of this case. And even look at the totality of the psychiatric testimony, not just what their ultimate conclusion is. Look at Dr. Seibel's testimony. He says he believes Weaver needs supervision due to his deficits in judgment and thinking. It was noted that Weaver was harassing staff and other patients. He was being inappropriate with them. So ultimately, it sounds to me like he's agreeing with the court's ultimate decision. He's saying this guy needs supervision. Dr. Seibel reports, I think it was mentioned, Weaver needs prompts even for basic grooming and bathing. His hygiene is poor. And it wasn't just that he wanted his case to go away like any criminal defendant would. It's that he did not understand the seriousness of his conduct. That's what the psychiatrists were really saying. That's why he thought the case should just go away. It's not that he wanted it to go away, he thought it should just go away, because he didn't appreciate the seriousness of it, and that's a problem. In fact, Weaver, he mainly seems concerned with, and these are quotes, winning the case and getting a good deal. Dr. Seibel ultimately opines in his report, he says, quote, taking into consideration community safety, inpatient treatment at Heartland Behavioral Health Care is the least restrictive alternative for his care. That's pretty clear to me. So again, we have psychologists agreeing with the court's ultimate result, saying for the sake of the community, this guy needs to be in an inpatient facility. Now on the intellectual disability subject to institutionalization by court order, which is a huge mouthful, to be considered that, a person has to have at least a moderate level of intellectual disability, which is the 55 that was mentioned, I believe. Now you have in 1987, Weaver's IQ score was found to be 54. And then you have Dr. Cowan stating that the results of IQ tests are consistent and reliable over time. So the 55 score in 1987 is just as reliable today as it was in 1987. That's his testimony. I think and then you look at, in 2016, there's another IQ test where he gets a 57, but what Mr. Brown conveniently leaves out is that Dr. Biscaro notes that there's a 95% probability that Weaver's IQ actually fell between 54 and 62. So there's a possibility or probability that it could be 54, which would be less than the 55 threshold. So Dr. Seibel, Dr. Biscaro, they both note that Weaver's insight and judgment were limited. Again, that they didn't appreciate the seriousness of his charges. There was something mentioned about adaptive problems not being noted. I think that's totally incorrect. Adaptive problems in communication and self-direction were noted by these psychiatrists. I think that was a big part of a couple of the reports, so I think you'll see that. Again, the court wasn't required to simply blindly accept the psychologist's ultimate conclusion that you have a mild intellectual disability. When you look at all of these factors, you look at the totality of the case again, and when you look at the fact that it's at least extremely close, I think in that situation it's not hard to see why, from the trial court's perspective, that there's a tie, it would go to the runner, because, so to speak, because this is a very serious thing we're talking about here. These are very serious charges. These are very disturbing charges. And you've got these tests that are right on the line, and you've got an older test that's under the threshold needed. You've got a new test that could be, if you look at the potential range.
With that, counsel, your time is up.
I would just ask that this court affirm the judgment of the trial court. Thank you.
Thank you. And Attorney Brown, you have 3 minutes and 15 seconds.
Thank you, Your Honor. And respectfully, I think under the clear and convincing evidence standard, if there's a tie, it should go to the defendant. I mean, this isn't a preponderance of the evidence, it's clear and convincing evidence, the highest standard we have in civil law. With respect to whether the rules of evidence apply to these kind of proceedings, the Supreme Court of Ohio said these are civil proceedings, so certainly not miscellaneous criminal proceedings. It looks an awful lot like a civil trial. Maybe it's more like a preliminary hearing in a criminal case. The rules of evidence apply to both of those. I believe the rules of evidence should apply here as well. With respect to the mental illness and the state and the trial court focused a lot on Dr. Seibel's testimony. Dr. Seibel said that Mr. Weaver has no mental illness. Dr. Cowan said the same thing. Now, there's certainly a difference between some hyper-technical definition of mental illness and the statutory definition, but I think the experts had the statutory definition in mind when they said that. Certainly Dr. Cowan did. That's why he was appointed, to determine whether Mr. Weaver is subject to institutionalization. So when he says that Mr. Weaver has no mental illness, he's saying that with the statutory definition in mind. So, this isn't a case where we have countervailing evidence. All of the experts looked at this and said he has no mental illness. With respect to the moderate intellectual disability, Dr. Cowan's was the only testimony in that regard. Dr. Seibel said, I'm not qualified to testify about that. That's why the court appointed Dr. Cowan. Dr. Cowan said he's in the higher range of mild disability. He's significantly above where someone with moderate deficits in adaptive functioning would be. And if we look at the facts, Mr. Weaver was able to live independently with minimal oversight. He's able to drive, he's able to hold a job. None of that indicates that he has moderate deficits in adaptive functioning. And with clear and convincing evidence as the standard, the evidence simply wasn't there. So even if this court finds that there was clear and convincing evidence that he committed the offense of kidnapping, which our position is that there wasn't, the state can't meet the burden on the second part of it, is he's subject to institutionalization. That's why we're asking the court to reverse the judgment of the trial court retaining jurisdiction over Mr. Weaver. And if the court has no further questions.
Appears we do not, so thank you very much, both of you, for your arguments here today and your presentations. The court will take the matter under advisement and issue a decision in due course. Clerk of Courts will mail each of you a copy of the court's decision on the day it's released, and this court's opinions are also posted on the Supreme Court's website where you can check. Again, thank you both for your presentations.
Thank you.